Hello and welcome to the pre-deployment legal issues briefing for this Yellow Ribbon program event. Today is December 6th, 2020, and I am Major Kurt Kafferlin, the Vermont National Guard State Judge Advocate. We're going to take a quick look at a few things today. We're going to look at wills, life insurance and other non-probate estate matters, powers of attorney, advanced medical directives and living wills, child custody protections, the Service Member Civil Relief Act, the Uniformed Services Employment Rights and Reemployment Act, and you're also going to get some contact information for the JAG office. First, let's talk a little bit about wills. All deploying service members have access to legal services, and that includes the ability to have a will prepared. A will can be a very important document in certain situations. If a service member has minor children, then a will allows them to appoint a guardian for those minor children in the case of their death. If a service member wants to ensure that their property goes to a specific person or specific people, then a will allows them to do that as well. If the person wants to disinherit or make sure a family member does not get any of his or her property, then a will can do that as well. A service member also should consider a will if they have significant assets. While all states have laws that function like a default will, what is commonly called intestate succession, these laws are different in every state. There are many situations for a married service member where their spouse does not get their entire estate by default, and a will may be necessary. It is also important to remember that spouses and other dependents of deploying service members also have access to legal services, which includes the ability to have their will drafted. But will drafting is a legal service. The military cannot make anyone get a will, even if it would be a good idea for them. It's also important to remember that the original of a will is what is important. Courts will not take copies. A will is actually a personal document, not a military document, and the original is given to the service member to keep it safe. For example, in a fireproof safe, a safety deposit box, or by filing it with the probate court for safekeeping. The military does not hold on to original wills for service members, so it is a personal responsibility to keep it safe. Writing on a will after it is executed can lead to it being an invalid will. A new will should be prepared if a change needs to be made. Let's ask ourselves a few questions. What if a service member needs a will prior to deployment, but has not yet completed one? The primary time to do a will is during soldier readiness processing. However, a service member should contact the Office of the Staff Judge Advocate to set up an appointment if he or she did not get a will during SRP for some reason. But remember that last-minute appointments may not be at convenient times, and that you may have to be very flexible. What if a spouse of a deploying service member would like to have a will drafted? The spouse should contact the Office of the Staff Judge Advocate to set up an appointment. But remember that because a spouse's appointment can take place after a deployment is started, such appointments will be scheduled based on the availability of attorneys. What if the service member has lost the original will? Well, if the original is lost, then it is the same as not having a will at all. A new will should be drafted and executed. What if the will was prepared and executed a long time ago, such as before a prior deployment? Remember that wills do not expire. As long as the original will can be located and still meets the person's intent, then everything is all set. If a person has gone through a major life change, like being married or divorced, or having their first child since doing their will, then that person should do a new will. However, if a person simply has another child, meaning they had at least one child when they did their will originally, then that person probably doesn't need to do a new will because the gift is most likely to the children as a class and not as specific people. While wills are very important, they do not take care of everything. Things like life insurance policies and various types of investments are paid out to a named beneficiary rather than through a will. These things don't pass through a will and are not handled in probate. A person should make sure that their beneficiaries on their accounts are up to date before deploying. That means checking the beneficiary designations for any sort of retirement account to include IRAs, 401ks, any sort of state public retirement, or a thrift savings plan. A service member should also make sure that their Soldiers Group Life Insurance, SGLI, is up to date as well. This should have been taken care of through the SRP process. Beneficiaries for other life insurance policies, including those offered through a civilian employer, also should be updated. Another thing that doesn't always pass through someone's will is real estate. In certain types of co-ownership situations, the property may pass by operation of law rather than through the will and the probate process. This is most common with married couples who purchase the real estate together. In such cases, they're usually held by something called tenancy by the entirety, and when one spouse dies, the remaining spouse is automatically the sole owner by law. There can be co-ownership as joint tenants with right of survivorship as well, in some cases of unmarried persons, whether they're a couple or not, and this works much the same way. However, usually non-married co-owners hold property as what we call tenants in common, which would mean that a co-owner's interest in the real estate would pass through the will and through the probate process. Now let's talk a little bit about powers of attorney. A power of attorney is a document that gives someone the authority to act as the agent of another with regards to money and property. A service member has the ability to have a power of attorney drafted as part of pre-deployment legal services. However, a person doesn't need a power of attorney for someone else to pay their bills. Those to whom a person owes money will take it from anyone as long as it's green. Access to accounts can be done in other ways, such as adding someone as a custodian on a bank account. And most bills can be paid by setting up automatic recurring payments. Even if the bill cannot be paid this way, most banks have services where the bank will send recurring checks. Powers of attorney are subject to potential abuse and are only advisable if there is an actual need. There are two common types of powers of attorney: general powers of attorney and special ones. General powers grant broad powers to the maximum extent that a state's law allows. There are a few limitations, but for the most part, it grants the power for the agent to do anything the person could do if they were there. Special powers of attorney are for more specific purposes or specific transactions. These are most common in the case of real estate transactions. Powers of attorney can be durable or springing. Durable powers of attorney can be used immediately after they are executed and are not affected if the person granting the power becomes disabled, incompetent, or incapacitated. Springing powers of attorney, on the other hand, only take effect upon the occurrence of a certain event. This is typically when the person granting the power becomes disabled, incompetent, or incapacitated, and no longer has the ability to handle their own money or property. If a power of attorney is going to be used for a real estate transaction, that normally requires a special power of attorney. Special powers of attorney for real estate are often very specific as to a certain real estate transaction. Remember, lenders often have their own power of attorney forms that they require and may not accept a power of attorney prepared by someone else, even if the preparer was an attorney. Checking with the lender or real estate agent is always recommended. Let's ask ourselves a couple questions about powers of attorney. What if a service member did not get a power of attorney during soldier readiness processing? That person probably did not need one and was probably advised that it was not necessary for their situation. However, if a specific need for a power of attorney has arisen since SRP, that service member should contact the Office of the Staff Judge Advocate to set up an appointment. What if something else changes, where a service member needs to execute a power of attorney after they are deployed? Well, there's no guarantee of legal services in theater. However, a service member should work through their chain of command to coordinate legal services. Every battalion level headquarters should have a paralegal that can assist, and brigade level headquarters or above are staffed with attorneys. Let's talk a little bit about advance medical directives. This is a document that allows a person to make several decisions in advance relative to health care in the event that the person becomes unable to make their own health care decisions. They can appoint an agent to make their health care decisions, and they can also consent to or limit what sort of medical treatment that person will receive. Some examples are a request not to resuscitate or to withhold life-sustaining treatments such as nutrition or hydration. An advanced medical directive includes those documents that are commonly called healthcare powers of attorney, living wills, and DNRs. An advanced medical directive may be prepared by a legal assistance attorney, but it is something that a person can easily take care of on their own by utilizing some of the available resources. In the state of Vermont, the best resource is the Vermont Health Department. They have an online service where a person can prepare and register an advanced medical directive. The website is showing on your screen. The forms used guide a person through the process, and the registration allows any healthcare provider to access the document, even if they don't have a paper copy. Other states have similar resources too. If a service member cannot locate their state's resources, they can contact the Office of the Staff Judge Advocate to point them in the right direction. I'm going to speak very briefly about some child custody protections that are available during deployment. Child custody situations can be very complicated, but there are a few basic legal protections I want to tell you about. Federal law under the Service Members Civil Relief Act allows for stays of proceedings, and this applies even in child custody matters, so that the case can be put off until the service member returns home. Also, temporary custody orders that are issued during a deployment must expire at the end of that deployment. Also, absence by the parent for the purpose of the deployment cannot be the sole factor in considering a custody decision, such as whether to modify a custody order. Vermont law also provides some additional protections under the Military Parents' Rights Act. One of these significant protections is the ability to temporarily delegate parent-child contact rights to another family member or someone the child lives with, such as a grandparent or a step-parent. This process would mean going to court and asking the court to transfer that parent-child contact right temporarily. In addition to Vermont, most states have similar protections to that they have here. Also, a legal assistance attorney in the Office of the Staff Judge Advocate can point service members or their dependents to the laws that protect them. However, hiring an attorney who practices in family law and is able to appear in court for you is advisable if you have a child custody situation. We're going to talk very briefly about the Service Members Civil Relief Act, or the SCRA. The SCRA provides certain benefits and protections to service members while they're deployed. Some of the most significant of these protections are reducing interest rates on loans, credit cards, and other debt to 6%, allowing early termination of residential or motor vehicle leases, allowing termination of cell phone contracts without penalty, but if there's any unpaid balance on a device being purchased through installment payments, those still must be paid. Staying civil court proceedings, whether the service member is a plaintiff or a defendant. Protections against default judgments, that means losing a case for failing to answer or appear in a civil court proceeding, including the ability to set aside a default judgment if the court mistakenly enters one. Suspension of statutes of limitations for civil court claims a service member may have, and certain protections against eviction for a service member or his or her family. The Office of the Staff Judge Advocate can provide you with form letters to exercise some of these benefits. For instance, a letter to send to a creditor to reduce your interest rate to 6%, or a letter to send to your landlord to terminate your residential lease. There are some other protections available in addition to the ones I have listed. If a service member or his or her dependents face some sort of adverse situation with regards to a civil court proceeding, a lien, a contract, or some other sort of civil law circumstance, then there might be a protection and they should contact the Office of the Staff Judge Advocate to set up an appointment. But remember that the C in SCRA stands for civil. It does not apply to criminal cases. Criminal courts do not have to put a case on hold and may issue a bench warrant if someone fails to appear. Next, I'm going to talk about the Uniformed Services Employment Rights and Reemployment Act, or USERRA. You will probably hear later from the Employer Support of Guard and Reserve, or ESGR, and they're going to provide you with information on USERRA as well. However, because this is a law, I want to provide you with a legal perspective on USERRA. USERRA provides certain employment protections to service members, and these are especially important during deployment. However, many of the provisions apply equally with regards to drill weekends and annual training. In general, USERRA prohibits employment discrimination based on past, current, or even possible future military service. It also protects reemployment rights for persons absent from employment because of military service, such as for a deployment or for drill weekend or annual training. It also preserves benefits for a person absent from employment because of military service. First, let's talk about the discrimination protections under USERRA. A civilian employer cannot discriminate against a service member just for being in the military, even if that military service requires absence for drill weekend, annual training, deployments, and even full-time duties such as ADOS or AGR. Discrimination can take many forms. It can be failing to consider someone for a promotion. It can even be things as serious as termination. Let's also talk a little bit about the protections of benefits. USERRA does allow service members to keep their employer-provided health insurance, but for service longer than 30 days, an employer doesn't have to pick up the tab and pay their portion of the premiums, and the employee has to pick up those extra costs. This has little application during deployment when TRICARE is available. The most significant protection of USERRA relating to deployment is the right to be re-employed upon return from deployment. This re-employment right is a significant one. In most cases, if a service member requests to be reinstated at their job, then the employer has to promptly reinstate them. The service member has up to 90 days upon return to request re-employment if the tour is for 180 days or more. In some ways, it is like they were never gone. When they come back, they still have their seniority, plus any additional seniority they would have attained while they were on deployment. Also, for purposes of their pension, that time on deployment counts as time in service with the employer. USERRA does have some limitations. It does not protect brief and non-recurrent employment like temporary positions. An employer can also claim undue hardship, which can happen with very small businesses. If it becomes impossible for an employer to restate the service member due to some change in circumstance, then there might not also be protections. For example, if there was a large company that had a couple factories and they closed one down completely in the area where the service member lived, then they might not have the ability to reinstate the service member. If someone has a question, they should contact the Office of the Staff Judge Advocate and make an appointment. The phone number is on your screen. That phone number is 802-338-3082. You can also contact Ms. Lisa Petrigill, and her email address is on the screen as well. All appointments are held at the Green Mountain Armory on Camp Johnson in Colchester. Remember that if you're coming for a legal assistance appointment, bring your military ID, and if you're a dependent, you must bring your dependent ID. You can also contact, for USERRA issues, Employer Support of Guard and Reserve, and their contact information is on the screen as well. I hope you've enjoyed this legal briefing and found it useful. Have a good day, and thank you for your service.